let me know.
Yeah, thank you.
Is that up there?
It's for 080. That's the Betsy application.
Oh,
You just approve the publication.
Ain't that him in the picture?
Yeah.
He's up there.
Yeah.
Yeah.
Oh, 080.
During proceedings. For Gary's staff.
Okay. Okay.
Staff employees in Southwest. I think that's it.
That's clear.
Mm-hmm.
We found it. Gary? We found him. He's in Little Rock. That looks like him on the. It is. All right. Need to be up there anyway for something. Good attitude.
Was your son officially in Denver?
Been there 2 months.
2 months now.
It did take him long to get there.
He was happy for the move.
Yeah, no, he likes it over there.
8.
Do a trip up to Seattle and just to see it. But after hearing your traffic stories, that's.
We can get on.
Little Rock, y'all ready? I didn't get a comment.
I don't think they heard you.
Fort Smith, are y'all ready?
Yes, sir.
All right. Little Rock, y'all ready?
They're still muted.
Randy?
Yes.
Okay. Little Rock?
We don't hear you. Don't unmute them.
Do what?
They're muted.
Call Larry. I think that's what I was doing. You got him? We-
trying to unmute you.
Okay, well, we keep trying to talk to you. He said we're trying to-
Can't remember.
Who's up top?
Oh, okay. I just saw him walk by.
Try again. There we go.
Larry?
Okay. Elevator, can you hear me?
Everybody ready?
Yes, sir.
Yes, go ahead.
Good morning, ladies and gentlemen. This is the December 10th meeting of the Arkansas Oil and Gas Commission, a division of Arkansas Energy and Environment. I will turn it over to the director now.
Thank you, Chairman. Since we are in a location here, take over as this.
Yeah.
Be here. So here you go. Oh, okay. Since we're in several different locations, I'm gonna go ahead and do a roll call, see who's here, so you have to attendance. Commissioner Langley. Chairman Langley.
Yes.
Okay. Vice Chair Weiser. Commissioner Phillips,
Yes.
Commissioner Smith. Commissioner Wolford,
Here.
Commissioner Thomas,
Here.
Commissioner Reiner,
Here.
Commissioner Lawson,
Here.
Commissioner Westfall.
Here.
And we will need a vote to excuse Commissioner Smith, who is not present. I have a motion, Commissioner Vice Chair Geiser, second.
Second for the excusable Commissioner Smith.
Hearing no second, we won't have an excused absence vote by the commission or commissioners. Turn it over to bring up to the beginning.
Thank you very much, Director Campbell. Good morning, Commissioners. First item on the regular document number 074-2024-10. Applicant is Plywood. Is Mr. Parkins, subject is extension of temporary abandonment status. Location is section 29, Township 8 North, Range 14 West. County is Conway. Field is B43, well spacing area. Mr. Perkins, you are recognized.
Thank you, Judge Moulton. On page 2 of the application, there's a list of the pre-filed exhibits. Those include Exhibit A, a list of the parties receiving notice. B is the fluid level test of December 4th, 2023. C is a proof of publication. D is an affidavit of notice to interested parties. The originals of C and D have been provided this morning to Mr. Pilkington. I would ask that those be admitted.
Motion is granted. Those exhibits are made part of the record.
As you stated, this is an application to extend the temporary abandonment status of the Criswell 814 14-29H20 well. This particular well is part of a 3-well group that substantially communicated with each other and produced high volumes of water. So that that complicates a little bit the effort to put it back into service. It requires that all 3 wells be involved in that process. But nevertheless, this particular well requires a tubing pull, installation of gas lift valves with packers, and resetting 2 or 3 large gas lift compressors for the 3-well set. Nevertheless, Flywheel believes it's economical to retain this well to return to service because the last combined production from the 3 wells was about 950 MCF a day, with approximately 250 to 300 barrels of water a day. Applicant believes the wells can be returned to production economically, and the current projected break-even price is approximately $4.20 an MCF. Flywheel would, of course, agree to all of the commission-imposed restrictions that come with the extended abandonment, temporary abandonment status.
Thank you, Mr. Perkins. Commissioners, any recusals or abstentions on this matter? Hearing none, any questions for Mr. Perkins? Perkins, does that conclude your presentation on this docket?
Yes, it does.
All right, thank you very much. With that, I call the evidentiary part of the hearing to a close. This matter is ready for adjudication. Is there a motion from the commission?
Move we approve. This is Commissioner Wolford.
Second.
I'm sorry, we get a motion and a second. I think the second was from Commissioner Lawson. Is that right?
Correct. Yes.
Thank you very much. All in favor, show of hands. Motion passes. Next item on the docket, regular docket number 075-2024-10. Applicant is Flyway Energy Production, attorney of record Mr. Perkins. Subject is extension of temporary abandonment status. Location is section 16, township 8 north, range 14 west. County is Conway, field is B43 well spacing area. Mr. Perkins, you are recognized.
Thank you, Judge. The pre-filed exhibits are shown on page 2 of the application. Those include Exhibit A, a list of the parties receiving notice. B is the fluid level test of December 4th, 2023. C is a proof of publication. D is an affidavit of notice. The originals of C and D have been provided this morning to Mr. Pilkington. We would move for the admission of those exhibits.
Motion is granted. Those exhibits are part of the record.
I have one witness with me this morning, Mr. Brent Schulte. He has been previously recognized as an expert in petroleum engineering by this commission in docket number 064-2022-07. I would ask that his credentials be recognized and that he be sworn.
That motion is granted. His credentials are recognized as an expert. Schulte, would you be so kind? You swear affirm the testimony about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much, sir. Please proceed, Mr. Perkins.
This is another request for extension of the temporary abandonment status. This one is for the Green Bay Packaging 814 number 2-16H well in Conway County. This particular well is a marginal producer and is I guess a toss-up for returning to production, but the costs of doing so are minimal, and so it remains a candidate for that. However, Flywheel's primary interest in retaining this well is because it is an especially good potential candidate to inject CO2 for CO2 sequestration as those regulations continue to evolve. And I have brought Mr. Schulte here this morning to explain why it's particularly well suited for that. And so, Brent, first just remind the commission again who you are and what your position is at Flywheel Energy.
Yes, hi, Brent Schulte. I'm a production engineer, production advisor for Flywheel. Have also had most involvement with saltwater disposal over the last 4 or 5 years with the company.
All right, and so this is an unusual request in my experience to want to retain a well because of its potential for CO2 sequestration. So can you explain to the commission just briefly how that would work and why this particular well is especially well suited for it?
Sure. Kind of building off what you said, just evolving regulation. So this particular wellbore is adjacent to one of our compressor stations that actually has an amine treatment plant for the purpose of removing CO2 that's currently emitted. And with that makes it one of our largest CO2 emitters, as a company here in Arkansas. So it also, being adjacent to the compressor station, it also has a dedicated pipeline, no other wells serviced off that pipeline. So this, with its location, it's already pre-existing transportation, it makes this a prime candidate for a pilot for CO2 sequestering via injection in this well. So, and all that CO2 originates from our gas wells. So we would like to have the opportunity to fully evaluate from a geologic as well as a economic standpoint for that potential.
And what, you wouldn't be injecting into the Fayetteville Shale, so tell the commission why it's well suited for injection in some other formation.
Correct. So we have some proven injection capability in the area. It's stratigraphically above the Fayetteville. Need to evaluate the pressures, the phase phenomena during injection, but it would be targeting a similar injection formation that we currently inject in from a saltwater disposal standpoint, or as an example.
Pass the witness.
Thank you. Commissioners, any questions? All right, seeing none. Anything else you would like to add, Mr. Parkins?
Only that, of course, as with all of these applications, Flywheel is happy to comply with the commission imposed restrictions on an extended temporary abandonment well.
Thank you, Mr. Parkins. Commissioners, any recusals or abstentions on this matter? No, for the record, there were none. If that concludes your presentation, Mr. Parkins, I'll call the evidentiary part of the record to a close. Matter is ready for adjudication. Is there a motion from the commission?
Move we approve as presented. This is Commissioner Lawson.
Commissioner Lawson has moved to approve. Is there a second?
I'll second. This is Liner.
Second by Commissioner Leiter. All in favor, show of hands. I'm hoping that it was unanimous, but I can't quite tell.
You got 3 votes in South Arkansas.
Thank you, Mr. Chairman. The problem, commissioners, is when we have two video screens, and when one of you is speaking, it blows up that screen, but then it shrinks the other screen, so I can't see anybody on the other side. All right, next item on the regular docket number 076-2024-10, Flywheel Energy Production LLC is the applicant. Mr. Perkins is the attorney of record. Subject is extension of temporary abandonment status. Location is Section 2, Township 7 North, Range 15 West. Field is county is Conway. Field is B43 well spacing area. Mr. Perkins, you are recognized, sir.
Thank you, Judge. Page 2 of the application includes a list of the pre-filed exhibits. Those include Exhibit A, list of the parties receiving notice. B, of the fluid level test of September 27, 2023. C is a proof of publication. D is an affidavit of notice. The originals of C and D have been provided this morning to Mr. Pilkington. We would move for the admission of those exhibits.
Motion is granted. Those exhibits remain part of the record.
This is another application for the extension of temporary abandonment. This one for the McLaren Mary 7-15 4-2H35 well. This well is part of a 6-well group that substantially communicated with each other and produced high volumes of water. And an effort to return to production will necessarily involve all 6 wells. So that's, again, it just complicates the process a little bit. This particular well would include, the workover would include round tripping all the tubing strings and installing gas lift strings. But the 6-well group combined last produced about 750 to 800 MCF a day, and Flywheel believes that it can be placed back into production economically with a reasonably foreseeable gas price. Its currently estimated break-even price is $3.64 an MCF. We would move for approval of that. And Flywheel would, of course, agree to all of the commission imposed restrictions.
Thank you, Mr. Parkins. Any questions for Mr. Parkins, commissioners? Seeing none, does that conclude your presentation on this docket?
It does.
All right, I'll call the evidentiary part of the record to a close. Matter is ready for adjudication. Is there a motion from the commission on this docket?
Move we approve. This is Commissioner Wolford.
Commissioner Phillips moved to approve. Is there a second?
Second, Commissioner Wolford.
Commissioner Wolford has seconded. All in favor, show of hands. Motion passes. Next item on the regular docket, docket 077-2024-10. Applicant is Flywheel Energy Production LLC. Mr. Perkins is the attorney of record. Subject is extension of temporary abandonment status. Location is Section 5, Township 10 North, Range 14 West. Counties Van Buren, field is B43, well spacing area. Mr. Perkins, you are recognized, sir.
Thank you, Judge. The pre-filed exhibits are listed on page 2 of the application. Those include Exhibit A, list of parties receiving notice. Exhibit B is a fluid level test of August 28, 2024. C is a proof of publication. D is an affidavit of notice. The originals of C and D have been provided this morning to Mr. Pilkington. Would ask that those exhibits be admitted.
Motion is granted. Those exhibits are part of the record.
This is an application for the extension of temporary abandonment status for the Reed 10-14-2-5H well in Van Buren County. The applicant needs to add a plunger lift and possibly conduct a lateral clean out of this well. Flywheel believes that it can be returned to production economically with reasonably foreseeable gas prices, and the current estimate to break even is $4.26 per MCF. Flywheel would, of course, agree to all the commission imposed restrictions.
Does that conclude your presentation, Mr. Perkins?
It does.
Commissioners, any recusals or abstentions on this matter? For the record, there were none. With that, I'll call the evidentiary part of the record to a close on this docket. Matter is ready for adjudication. Commissioners, do I have a motion?
Motion to approve, Commissioner Westfall.
Mr. Westfall is moved to approve. Is there a second?
Second, Commissioner Lawson.
Commissioner Lawson has moved, has seconded. All in favor, show of hands. Motion passes unanimously.
Judge, I'd like to just add one brief comment, as I frequently do in December each year. Unfortunately, I only have an updated list of wells as of July 25th, 2024, but Brent can update that for you. As of July 25th, there were out of the Flywheel wells that had been temporarily abandoned when they took over, or since then, 114 have been returned to production and continue to produce, and 117 have been plugged and abandoned. So I like to occasionally remind you that they do actually do something with these wells when we come and apply for these applications. And Brent, can you update those numbers at all off the top of your head?
Sure. Just on the P&A account, we're actually plugging an additional 2 wells this week and next week as well. Just further evaluation and realize that weren't viable. So committed to plug those.
Thank you, gentlemen. Commissioners, any questions? All right. Thank you very much. Thank you, Mr. Perkins.
Thank you.
All right, next item on the regular docket, docket number 080-2024-12. Betsy Production Company Incorporated is the applicant. Ms. Clegg is the attorney of record. Subject is the establishment of field rules. Location is Section 25, Township 15 South, Range 18 West, County's Ouachita, and the field is Pace City. Ms. Clegg, I know that you were, I believe, on Zoom and you are recognized.
Yes.
Jerry, I need to recuse.
We got to recuse. Mr. Thomas needs to recuse.
Thank you very much, Mr. Chairman Langley, as well as Commissioner Thomas. We have one recusal. Any other recusals? All right, now for the record, there were none except for Commissioner Thomas. Ms. Clegg, go ahead and proceed, please.
Betsy Production Company, Inc. and Red Oak Operating LLC are seeking an order for the establishment of field rules for the Travis Peak formation of the Pace City Field, which is established as a separate source of supply in the applicant's Virginia number 1 well, located 2,446 feet from the south line, 280 feet from the west line of Section 25, Township 15 South, Range 18 West, in Ouachita County, Arkansas. We have the following pre-filed exhibits. Exhibit A is the well location plat for the Betsy Production Company, Inc., Red Oak Operating LLC, Virginia number 1. Exhibit B is the structure map for the Virginia number 1 well, reflecting the proposed unit to consist of the northwest quarter, the southwest quarter of Section 25, Township 15 South, Range 18 West, in Ouachita County. Exhibit C is the log for the Betsy Production Company at Red Oak, Virginia number 1 well. Exhibit D is the list of interested parties. Notice was given to all interested parties on November 21st, 2024 by first-class mail, an affidavit to that effect, which has been furnished to staff. Exhibit E is the affidavit of notice to interested parties. And Exhibit F is the proof of publication. Notice was published in the Camden News, a newspaper in general circulation in Ouachita County, Arkansas, on November 20th, 2024. I have one witness, Mr. Mike Davis, president of Betsy Production Company, Inc., and I would ask that he be sworn.
Thank you, Ms. Clegg. Do you move the introduction of those exhibits?
I do.
All right. Your motion is granted. Those exhibits are made part of the record. And you have one witness, is that right?
That's correct. Mr. Mike Davis.
Okay, I think I see your witness, but I'm not positive. Yeah. Sir, would you be so kind as to raise your right hand? See you there. Perfect. Do you swear or affirm the testimony about given this hearing is going to be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, thank you very much. Ms. Clegg, you may proceed, please.
Mr. Davis, as president of Betsy Production Company, Inc., would you review Exhibit B, which is the structure map for the Virginia number 1 well?
Yes, ma'am. The structure map is contoured on the top of the hog marker, marker located about 150 feet above the top of the Travis Peak formation. All of the wells, the majority of the wells on the structure map penetrated through the hog marker, so it's a good marker to contour on. The prospect and the production unit appears to be a closure on the downthrown side of down to the north fault that you see depicted in the southeast corner of the requested unit. There is another minor fault to the north that's a down to the south fault. The well that we drilled in collaboration with Red Oak is basically in the graben between these faults, and it definitely appears to be a downthrown closure.
Mr. Davis, would you address 2 issues that staff have raised? One with regards to the lack of an ISOPAC map for the productive zone within this proposed field, and also to clarify the allowable, which is 30 barrels a day to the depth of 4,000 feet.
Yes, given the lenticular nature of the Travis Peak sands in the Pace City field, in the limited area that's shown on this map of 9 units, the sand doesn't appear in virtually any of the other wells. So an ISOPAC map would, first of all, been very, very difficult to create. And second of all, due to those factors, it would have been of no value. As to our request for an allowable of 30 barrels down to 4,000 feet. Commissioner Thomas and I discussed this. We reviewed the Pay City field. It seems that wells in the Pay City field have a tendency to make water early in their life, in spite of the best measures you can take to prevent that. And we just felt like that in protection of the correlative rights and then hopefully ultimately for the ultimate recovery of reserves from any of these lenticular sands down to a depth of 4,000 feet, that a 30 barrel a day allowable would be in the best interest of conservation of the resource.
And then if you would turn to Exhibit C, this is the log for the Virginia #1 well.
Yes, ma'am. There was more than one sand in this well that were productive or presumed to be productive by log interpretation and sidewall core analysis. The sand you see perforated on the log submitted is the deepest producing sand in the well bore. The well flowed initially from the 3 feet of perforations. It's on the pump now. It pumps about a little less than 2 strokes a minute. The well averages currently about 6 barrels of oil a day, 6 barrels of water. Some days the well is still flowing and then it'll unload itself and the production kind of bounces around a little bit, but that's the current status of the well.
To clarify, it is the applicant's request that any order issued by this commission only apply to this Travis Peak well and not apply to any previously drilled wells in the Travis Peak in the Pay City field.
Yes, there had been Travis Peak production in the field for decades. Some way, somehow, field rules were never applied for the Travis Peak. Our application is for our well and any subsequent wells going forward, but we request that it not affect any wells that have previously been drilled into the Travis Peak or completed in the Travis Peak formation.
That concludes our presentation.
Thank you, Ms. Clegg. Any questions, commissioners?
I got one. So if an offset operator, and I don't know whether they do or they don't, but if they have a well in the Travis Peak currently, if we adopt this, can they drill another Travis Peak well within the same 40 acres? I know you said the previous well is not subject to this, but is the acreage that they set on subject to this? By definition.
I appreciate your question. I appreciate you addressing that. That's one thing that we would like to be considered that we probably failed to put in our application. If we were to drill a subsequent well within the same unit, we would like the authority to produce it, provided that it's from a separate sand. So, you know, as far as another operator coming in and drilling a well, we have no objection to that whatsoever.
Yeah, and I don't even know if there's an offset Travis Peak well to you already. I don't know. I'm just
Diagonally to the northeast, by my interpretation, I believe there's producing Travis Peak well. It's difficult to tell where the Travis Peak quits and the Cotton Valley starts. Some people take the position that particular well is in the Cotton Valley. My own personal opinion is it's in Travis Peak, but I mean,
there's not anybody left to argue with you.
well, you know, it's a nice well, you know, and I think the commission staff determined it was in the Cotton Valley, and I'm sure I'm not one to argue with.
I got one more question, just curiosity. So about 10 years ago, you had an application that had a fault with existing wells around it, and
was applying for field roles. And the question come up about the square, and you read us the definition from Webster's of a square. You remember that? And yes, sir, I do. So it's in here in the second page, you said 40 acres in the form of a square. Is that are you referring to a perfect square or a rectangle? And the only way it ever really comes into play is if there's like a fault there where it takes up more linear footage along the fault. Well, which isn't gonna be the case in this one, and I know that, you know that, but the intent of our application was to ask for units comprised of a governmental quarter section. Okay. So that's more of a perfect square is the intent. Thank you.
All right, commissioners, any other questions? Ms. Clegg, does that conclude your presentation? Anything you would like to add based on the questions from the commission?
Nothing further.
All right, with that, I'll call the evidentiary part of the record to a close then. Any abstentions based on the presentation? Now for the record, there were none. This matter is ready for adjudication. Do I have a motion from the commission?
I move we approve as applied for.
Second.
I think it was Commissioner Phillips that moved and Chairman Langley seconded.
Yes, sir.
All in favor signify by show of hands. Motion passes unanimously. Thank you, commissioners. Thank you, Ms. Clegg.
Thank you.
I got to run home. We still got a little fun left. We got work to do.
We got an empty seat for you, Mike.
I don't need it that bad.
Thank y'all.
Thank you.
Have a good day. Yeah.
Commissioners, next item on the regular docket, docket 081 2024-12. Merit Energy Company LLC. Mr. Rankin is the attorney of record. Subject is the extension of temporary abandonment status. Location is section 24, township 10 north, range 27 west. County is Franklin, field is White Oak. Mr. Rankin, you are recognized.
Thank you, Judge Moulton. The pre-filed exhibits appear on page 2 of the application. They are Exhibit A, the list of parties receiving notice. Exhibit B is the fluid level test. Exhibit C is proof of publication, and Exhibit D is the affidavit of notice. B and D have been provided to counsel for the commission. We've moved for the introduction of the exhibits set forth in the application.
Motion is granted. Those exhibits are made part of the record.
This is the first extension for the Scott HP2 well. It was initially administratively granted in 2021. Merit has identified several potential recompletion zones. And before they can do that, they need to do a perf and squeeze on the casing here. For that workover, the target gas price would be $3.50 per MCF to make it economical. There are other wells producing in the unit, the Smith Henson #1 and the Scott 3-24, so the unit's held by production. The applicant would comply with the commission required restrictions on TA wells. With that, we would move for the temporary, the extension of the temporary abandonment status of the Scott HP 2-24.
Thank you, Mr. Rankin. Commissioners, any recusals or abstentions on this matter? No, for the record, there are none. Does that conclude your presentation, Mr. Rankin?
Yes.
All right. Any questions, commissioners, for Mr. Rankin? Seeing none, I'll call the evidentiary part of the record to a close. Matter is right for adjudication. Is there a motion from the commission?
I move we approve the extension.
Commissioner Lawson has moved to approve. Is there a second?
Second.
I'm sorry. I'm not certain which commissioner said that. I apologize.
Langley.
Langley. Chair Langley has seconded. Show of hands. All in favor? Motion passes unanimously. Next item, docket number 082-2024-12. The applicant is Merit Energy LLC. Mr. Rankin is the attorney of record. Subject is extension of temporary abandonment status. Location is section 7, township 10 north, range 26 west. County is Franklin. Field is White Oak. Mr. Rankin, you are recognized.
Thank you, Judge Moulton. The pre-filed exhibits appear on page 2 of the application. They are Exhibit A, the list of parties receiving notice. Exhibit B is a fluid level test of September of this year. Exhibit C is a proof of publication, and Exhibit D is the affidavit of notice to interested parties. Originals of C and D have been provided to counsel for the commission. We move for the introduction of the exhibits.
Motion is granted. Those exhibits are part of the record.
This is the first extension for temporary abandonment for the Ray 1-7 well. It was initially granted TA status administratively in October 2021. The applicant has identified potential recompletion zones in this well. However, just like the previous well, it would require a perf and squeeze, and for that workover to be economical, a target gas price of around $3.50 per MCF is what the applicant would like to see. There is a additional producing well, the Toby 1-7 in this unit, therefore it's held by production. With that, we would move for the TA status for the Ray 1-7 well.
Thank you, Mr. Rankin. Any recusals or abstentions on this matter?
Commissioner Westfall has interest in the well and recused himself.
Mr. Westfall has recused or excused himself or recused himself?
Recused. I'm sorry about that.
Thank you very much. Any questions for Mr. Rankin on this matter, commissioners? Seeing there are none, Mr. Rankin, does that conclude your presentation on this docket? Call the evidentiary record to a close. Matter is ready for adjudication. Is there a motion from the commission?
Move we approve. Commissioner Wolford.
Mr. Wolford has moved to approve. Is there a second?
Second, Commissioner Liner.
Commissioner Lawson has moved to a second? No.
Liner.
I'm sorry. All in favor, show of hands. I count all hands in the air. Motion passes unanimously. Last item on the regular docket, docket number 083-2024-12. Applicant is Merit Energy Company LLC. Mr. Rankin is the attorney of record. Subject is extension of temporary abandonment status. Location is section 17, township 8 north, range 29 west. County is Sebastian. Field is Ewing. Mr. Rankin, you are recognized, sir.
Thank you, Judge Moulton. The pre-filed exhibits appear on page 2 of the application. They are Exhibit A, the list of parties receiving notice. Exhibit B is the fluid level test of October of this year. Exhibit C is a proof of publication. Exhibit D is the affidavit of notice to interested parties. Originals of C and D have been provided to for the commission. We've moved for the introduction of the exhibits.
Motion is granted and those exhibits are part of the record.
This is the first extension request for the Wilson 4 well, initially administratively granted TA status in December 2021. The applicant believes that this well does need a workover, has some minor casing damage. It would be economic to repair at gas prices at $3.50 per MCF. There are additional wells produced unit, the Wilson AE number 1 and the Wilson number 5. The applicant would comply with the commission required restrictions on TA wells. We'd move that the TA status for the AE 4-17 Wilson, the AE Wilson 4-17 be extended.
Thank you, Mr. Rankin. Commissioners, any recusals or abstentions on this matter?
Commissioner Westfall recuses himself.
I thank you, Commissioner Westfall. Does that conclude? Any questions for Mr. Rankin, commissioners? And for the record, there were none. Does that conclude your presentation, Mr. Rankin?
It does.
Call the evidentiary part of the record to a close. Matter is ready for adjudication. Is there a motion from the commission?
I move we approve to, extension.
Commissioner Lawson has moved to approve. Is there a second?
Second.
I'm not sure who that was again because we've shrunk it a little bit, but
Langley.
Commissioner Langley, Chair Langley has seconded. All right, all in favor, show of hands. I count all hands in the air. Motion passes unanimously. Next item is staff docket. Commissioner Lawson. Okay. Yeah. Mr. Pilkington, how are you, sir?
Great. How you doing?
I'm here.
Sounds good.
My understanding is first docket on the agenda, docket number 8084A-2024-12. You would like to continue?
That's correct. There's a recent history of non-compliance with this operator, but the operator has recently reached out to us and has demonstrated, at least to some extent, that they're trying to come into compliance. So we're going to ask for a continuance until the January hearing so that we can hopefully get this matter resolved.
All right. Pinkerton, do you need a motion on that or just I can grant your continuance, correct?
I think I'll formally motion, and if you grant it, it's usually.
All right. I'll go, if that's in the motion, I grant your continuance. Next item on staff docket 085A-2024-12. Is this the same doc? Oh no, 085, different docket. Subject is request for well abandonment. Location is multiple, as well as it appears the county and fields are also multiple as set forth in the application. Commissioners, are there any recusal or on this matter? No, for the record, there were none. Mr. Pimpington, you are recognized, sir.
Thank you, Judge Moulton. There's going to be some testimony provided by Mr. Looney. I'm not sure if he's ready yet, but we'll provide that testimony here shortly.
Okay.
First, pre-filed exhibits. There are a lot of them here, so I'm going to try to summarize to abbreviate this.
Yes, sir.
This is kind of a unique situation. What we're doing is we're attempting to abandon a large group of old wells that have not been in production for decades. So part of what commission staff had to do here was attempt to find any contact information we could for operators that have been around or have not been around for a very long time. So exhibits 1 through 24 as pre-filed in our application are any of the old Form 1s, Form 4s, Form 5s, anything we could find to identify the contact information for these operators. So exhibits 1 through 24, we would move for those to be admitted. We would also move for exhibit 25, which is our affidavit of notice. Exhibit 26 is a copy of notice of hearing. Exhibit 27 is our well list for the wells that are going to be hopefully put in the program. Exhibit 28 is proof of public notice from the Arkansas Democrat Gazette. I have a new exhibit that I would also move for admission of. It will be exhibit 29. It is an updated list because we're removing 3 of those wells. Hopefully, commissioners, you have a copy of that document. It has 3 highlighted wells on an Excel list, and we'll provide the reasoning why we're amending. So I would move for admission of those exhibit evidence and move to amend the application to include exhibit 29.
Your motion is granted. Exhibits 1 through 29 are admitted into the record, sir.
Is Gary available there at the El Dorado office?
Yes.
I'm right here.
Okay, Gary, can you hear me?
Yes.
Okay. Thank you, Gary. And I think everybody knows who you are, but I just want to confirm you do work here and you're aware of how the abandoned orphan well program works, correct?
I need to swear him in.
Sorry.
Sorry. Sir, would you be so kind as to raise your right hand? You swear affirm the testimony you're about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth.
Yes, sir, I do.
Please proceed.
Okay, and Gary, you're aware, very versed in how the abandoned orphan well program works, correct?
Yes.
Okay, can you explain to the commission has filed this application?
Yeah, so as the commissioners are aware, we have a current project in the Stevens, Arkansas area. With that project, we first identified 220 some odd wells. Knowing that there may be others, staff has been researching records, going through what our database has and well files and scrubbed it down to where we found an additional group of wells. From that, we scrubbed some more. And we are left with the list that you have in front of us that we believe are the remaining wells that we cannot confirm that they were ever plugged or properly plugged. And therefore, we're wanting to put them on this AOW program. And then we can also include and add these to the current project that is ongoing that's funded through the Department of Interior with the federal grant.
Gary, I believe previously the list you provided had 38 wells. Is that correct?
Yes.
And I believe now there are 3 that we are removing from the list in a supplemental exhibit. Can you explain why we're removing those 3 wells?
Yeah, so sometimes through the life of well and subsequent operations from operators, not all the paperwork either gets filed or is maintained properly. And so I'm trying to clean up records for these 3 that are highlighted that may be, I'm unsure, but may very well be on an active lease of existing operators in that field. So at this time, I would ask that they be removed from the list and let me continue to work with those operators to see if they are indeed covered by their active leases.
Thank you, Gary. And just for further explanation, can you provide kind of the background on each of these operators as far as when's the last time they've operated or used any of these wells?
So there's a few names that I'm familiar with from early in my career. Most of these were before my time here and have not produced since that time period. I'll add that we've already began looking for these, and we have found about 12 to 15 of the wells that are on this 38 well list that staff has been reviewing currently. But as far as the operators, none of them are currently in existence and operate at this time and have not, as you said earlier, for many years.
And the basis for putting these wells into the program is the lack of production for the last 2 years. Can you confirm that that's the status, at least for the ones you found?
That's correct.
And then based on any production records, none of these wells have produced in the last 2 years. Is that correct?
Correct.
Okay. I have no further questions.
Commissioners, any questions for Mr. Looney? Is there none? Anything else you want to add
Just
to your
to clarify
presentation?
that with the amendment of the application, we're only seeking the 35 wells instead of 30. And it's updated through the new Exhibit 29.
All right, Commissioners, any questions for Mr. Pilkington? Seeing there are none, does that conclude your presentation, sir?
Yes, sir, it does.
All right, I'll call the evidentiary part of the record to a close. Matter is ready for adjudication. Commissioners, is there a motion?
I move to approve the abandonment request, excluding the yellow highlighted wells. The total abandonment would be 35 wells.
Commissioner Lawson has moved to approve. Is there a second?
Second. Langley.
Has seconded. Show of hands, all in favor? I see all hands up in the air. The motion passes unanimously. Thank you, Commissioners.
Thank you, Judge.
Next item on the agenda, open docket. Commission will now hear public comments concerning the following areas of Commission jurisdiction: whether or not waste of oil and or gas is taking place, or is reasonably imminent, the optimum equitable rate of production for each controlled source of supply, whether or not any rules and regulations currently in effect should be considered for revision, if additional rules should be considered, or any other matters brought before the commission over which it has jurisdiction. I do have one comment card from a former competitor on the road running circuit. I say former competitor because he is still running, but I am not. Mr. Reynolds?
Also a sprinter, so this will be less than 5 minutes.
We did have our share of smack over oil runs though. Robert?
In regard to the proposed,
Robert, have a seat. Sit down.
with regard to the proposed rules, K1 through K4, the statute speaks about public water supply. It doesn't speak about private water wells. Most water supply in Arkansas is private, not public utilities. And in my case, I'm speaking about the Sparta Aquifer. It covers about 58,000 square miles in 5 states. Most of it's in Arkansas. There's a little in southeast Missouri, western Tennessee, western Mississippi, and in North Louisiana. In 1996, the Arkansas Natural Resources Division, one of your sister agencies, declared a critical groundwater area in 5 counties in South Arkansas: Ashley, Bradley, Calhoun, Columbia, and Union. Since that time, they have made other determinations that 5 more entire counties in Arkansas, plus parts of 11 counties in Arkansas, are critical groundwater areas. In 1998, the United States Geological Service advised Union County that Union County must reduce Sparta groundwater consumption by 72% in 5 years, or risk inflicting irreparable damage to the Sparta Aquifer, which at that time was our only source of drinking water and industrial water. In 1999, the legislature passed Act 1050, enabling legislation. Union County got to work immediately, and over the course of the next 4 years, we spent a total of $65 million, back when $65 million was a lot of money. 88% of that money was local taxpayers and industry. 8% was federal and 4% was state money. The result was that we have begun a significant recovery of the water level of our aquifer. We have also worked with our friends in Louisiana. For some reason, the Sparta Aquifer doesn't recognize the state line. And we also maintain a network of water level monitor wells to be sure that what we're doing is still working. And I ask that you please consider in the writing of this rule, not just public utility water supply, but private water supply and conservation of that resource, as the Oil and Gas Commission does in all other endeavors. In every secondary recovery water flood field that I've seen in the last 45 years here, the Oil and Gas Commission specifically prohibits the use of fresh water. You can use brine, you can use air, you can use nitrogen, whatever, but you use fresh water to get secondary recovery of oil.
Thank you, Mr. Reynolds. Anything else?
Yes, sir.
Hold on a second. Maybe the commission might have some questions for you. Commissioners, any questions for Mr. Reynolds? Commissioner Weiser?
Robert, are you specifically referring to number 6 on K2?
I don't have K2. All I have is the statute. I don't have the proposed rule.
Yeah.
that would be, I don't see a page number here. K2.
Yeah.
Okay, K2.
Number 6, yeah. Local water utility is mentioned there.
A copy of an agreement with the local water utility supplying water to the mining facility, which certifies that the water usage by the mining facility will not negatively impact the local water supply and water rates of the local customers. That would cover part of it if that facility, the data mining facility, was going to buy water from a local utility, but most water is privately supplied.
Would including private water sources to number 6?
Yes. And I think specifically in the critical groundwater counties, a total of 10 counties and parts of 11 others. All of whom have taken some measures to help themselves stay out of permanent damage to the aquifer, as well as our friends in Louisiana have too. Thank you.
Any other commissioners, questions for Mr. Reynolds?
Matt, worth noting, Columbia County was the first county before we were declared a critical groundwater area that took steps back in 1984 to develop Lake Columbia as an alternative source of water.
Thank you, Mr. Reynolds.
Thank you.
Any other comments? If not, Director, I'll turn it over to you for your report.
Okay. We're going to talk about Commissioner Phillips' discussion of a square. We use the word of equilateral quadrangle to define a square. So we have several different things we need to go over for housekeeping, and then we'll go over the K rules, which I'll briefly go through, take any questions, and then we'll take a vote to initiate the rulemaking process for that rule package. First thing is the minutes from the last hearing are stand approved, and they'll be posted on the commission webpage. The other housekeeping item before you is, I believe everyone has a copy of next year's proposed hearing schedules. If you all had a chance to look at that, look at the proposed dates for next year. Any comments or questions on those dates? The one change we had to make in September, it'll be the 5th day, not the 4th, because it would be a conflict with the Interstate Oil and Gas Compact Commission on the week of the 23rd.
I didn't get that. What is that? Say that again, Larry, please.
On September 23rd, which was the original date, which would be the 4th Tuesday in September, that was in conflict with the Interstate Oil and Gas Compact Commission meeting. So we had to move that September hearing to the 5th Tuesday, which would be September 30th.
Okay.
So if there's no questions on the schedule or suggested changes, we'll take a vote. The only suggestion I've heard, and I'm not sure how to address this from your scheduling standpoints, and since we now have a Zoom potential, is the starting date or the starting times of 9 a.m. When we do a Zoom, it makes sense. When we have travel, sometimes it does. Any comments on whether 9 a.m. is a good time, or should some of the hearings when we all travel and meet in person be changed to 10 a.m.?
Or does anybody care?
Had to be a Little Rock together.
Yeah, when we go to Little Rock, be it 10.
10, yeah.
I'd say expense for overnight stay.
Right.
Do you want to change the Little Rock meetings till 10?
Yes.
Yes, sir.
You make that change. And the Little Rock meetings are generally the ones that we'll have in person. Okay, the next item, and I don't want this to get by us next year. Sometimes we neglect to do that in January. But approval of the stipends paid for in the coming year, 2025. Need a motion for y'all to get paid your stipends and expenses for the coming year.
Is this when we apply for a raise?
You can make a motion. Probably won't be agreed to, but you can try. So I have a motion for y'all to get paid next year.
I move we get paid, this is Commissioner Wolford.
Okay.
I second it, Langley.
Motion second, all in favor, say aye.
Aye.
Any opposed? Okay, that motion passes. You all be paid next year for showing up at the hearing. The next thing is just going briefly that was just approved with the commissioner, or actually the department will have two potential rule pack or legislative packages this year. Secretary Curry can speak more to those if he wants to, but one will be dealing with an amendment to the oil and gas statute to include the liquid pipeline program under PHMSA. And then if that's approved, we will adopt rules to include liquid pipelines, with the oil gathering lines and CO2 pipelines that may occur here in Arkansas. The other legislative package will deal with CO2 sequestration or storage. We amended our Gas Storage Act last year to allow the commission to seek primacy and adopt rules with regard to CO2 storage. That passed, and we amended Rule 23 to start that process. Since the permitting of Class 6 wells are currently an EPA program, to apply for primacy under that program and have the state issue those CO2 storage wells, we also have to adopt rules for a program equal to the federal program. And in order to do that, there's several provisions that we had to address with the standpoint of fees for that program, as well as bonding requirements and a long-term program that the state would monitor after the site were to close. So that will be included in a legislative package, and hopefully if it passes, that will then support the rules which we'll propose later on for CO2 storage. That rule package will be fairly extensive. Jay and I are working on it. I think it's 27 rules to deal with that program to implement the federal program. Okay, what you have before you is a rule package that was passed last year in 2 acts by the legislature dealing with crypto mining or digital asset mining. And as a result of that, those acts, they authorize the Oil and Gas Commission to regulate that activity. One of the requirements was to adopt rules to do that based on our existing oil and gas rules. Does everyone have a copy of the rules?
Are you on K2, K3, or K4?
I'm going to go through all of them real briefly. K1, 2, 3, and 4.
We'll start with K1. The reason the Oil and Gas Commission was selected, or maybe volunteered, I don't know how it happened, but the reason we're doing this is one, we did deal with this issue, as you recall, some time ago. We issued a couple orders dealing with crypto mining at a couple of marginal well sites. And we've also dealt with noise at compressor sites. And one of the major issues with the crypto mining has been the noise issue. So the statutes were fairly prescriptive in that they did not leave much to interpretation with respect to the regulation of these sites. They were fairly prospective, and consequently, our rules don't add much to what the statutes already say. Our rules primarily put in place procedures and processes to implement the statute, and they're more administrative as opposed to adding additional requirements that are not, specifically referenced in the statutes. The first is Rule K1, and it's simply a rule that defines who is eligible to apply and who is required to apply for a permit by establishing a limit on power usage. In other words, if you're doing something in your home, you're excluded from this rule. It also has a list of all the definitions used in the rules, most of which are already in the statute also. So K1 is generally a procedural and definitional applicability rule. Rule K2 deals with the actual permitting process. The fact that you need a permit. The permit will be good for 5 years. It specifies what's required in the application. In order to apply for a permit, it addresses those noise issues. But as you read the statute and you read the rules, there's no noise decibel level in the requirements. It's merely procedures to minimize the noise, use cooling methodologies, enclose the facility in a building, comply with local ordinances, a 2,000-foot setback, and other noise uses in industrial areas. So there's no a decibel requirement in the noise abatement process. And Rule K2 goes through the notice provisions for getting the permit. And obviously, as we have in our oil and gas rules, especially the UIC rules, if there's an objection, then that'll be processed before the commission for hearing and adjudication of that objection.
Is there a state limit on decibel for noise or federal?
Not that I'm aware of. One of the problems that we had doing noise at our compressors was the fact that the background noise in many areas were fairly high with truck traffic, road traffic, other industrial activities, just human activity. So it was hard to define something that wouldn't be in conflict with that. And we actually had some opposition from some of the industries who operate in those same areas that have background noises going on.
Do you or staff have a problem with including private water supply wells to number 6 and K2?
I don't know if I have a problem with it conceptually, but we would be denying a private owner from selling water. Is that what we would be doing?
It just says you have to have an agreement.
With the private landowner?
Yeah.
So if the private landowner wanted to do that, but that's fine with, I mean, what? We didn't think any private landowner would be supplying water to, as opposed to buying it from a local utility. But if the private landowner wants to be the supplier of water for a cooling, like, an agreement would be fine there too. So a public utility agreement or an agreement with the private landowner.
Yeah. Let's add that if you don't mind.
That's fine. In other words, whoever's using the water has to
Let's have that.
have an agreement with the supplier of the water. But in the case where the mining facility were to own the property and they wanted to drill a water well,
Yeah.
they would not need agreement. They would,
Agree with themselves,
they're
basically.
agreeing with themselves.
Yeah.
There'd be no prohibition on them doing that. Okay. I make a note here. I think it'd be hard to deny them drilling a well, but
Yeah.
we'll look at that. In any case, that's K2. K3 deals with transfer of that facility from one owner to another. It is very similar to how we transfer wealth, many of the same provisions. There's nothing new in here from that standpoint. Same process we use for wells.
Bond required.
Hey, Larry,
The bond required.
No bonds required. B for the permits required. Yes. Commissioner Lang.
that's what I was fixing to ask. Do we bond them?
No bond requirement, and there's no permit fee requirement. That was specifically not put in the statute.
Okay.
No, we'll go there if we wanted to.
Y'all charge us for permit and everything we do. We ought to charge them.
I know. That's why I say the statutes are fairly prescriptive to what we can and can't do. So these rules are more procedural than actually adding issues that are generically mentioned in the statute. The statute's fairly forthright, straightforward. And K4 is the enforcement procedures. Once again, these mirror the current enforcement procedures we have, issuing a notice of non-compliance or issuing notices of violation, and the types of violations that can be issued. And then also then goes into the fine or civil penalties that can be assessed. Again, those are specified in the statute. We don't use our particular amounts. They're specified in the statute. So those are the rules are being proposed. They've been through the governor's office, they've been through the department legal staff. And I would request a motion to initiate the rulemaking process for this rule package to move forward.
I so move with that additional language to K2 or 6.
And we have a motion by Vice Chair Weiser to move the rule package forward with the amendment of including private water well agreement, should that well be used for water usage at the facility. You have a second?
Second.
That Commissioner Lawson?
Yes.
We have a motion and a second. All in favor, say aye. Aye. Anybody opposed? The motion carries, and we'll begin the rulemaking process for this rule package. That's all I have, except since our last meeting, I'm sorry, Commissioner Phillips, didn't have your Christmas lunch. It was a short meeting. I wish you a Merry Christmas and a Happy New Year anyway, if we don't see you before then.
Thank you.
Thank you.
Yeah, thank you.
Chairman Lang, back to you.
Yes, it's December 10th meeting and it is adjourned.